support of the motion, wherein I adopted and argued the 3 jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is in material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this statute, my Lord, nullifies this entire proceedings completely and totally. Because count 7, my Lord, does not exist in the laws of this very country. Whereupon points of law, I would make specific references to the ratio that came down from the Supreme Court, where my Lord, Garba, explicitly stated that count 7 should be changed. That hasn't been done, my Lord, and this court is in contempt of the Supreme Court binding order. My Lord, the entire argument of the respondent, I'm sorry to say, collapses on just one single point, not many, just one. The Supreme Court pronouncement on the statute of the written law is immovable. It is enshrined in the Constitution of this very country unless a law is written. Unless it is written, defining that very offense, no trial, no conviction can ever take place. And it is my submission, my Lord, that this very morning, as we stand in this very hallowed chamber, count 7 does not exist. I've not got the repeal law that will come later. Count 7, my Lord, destroyed this entire trial because Supreme Court gave an explicit order which wasn't adhered to.
The consultant, you have to go to the defendant to tell him the procedure here. You have the practice of front-loading. I think he has filed his written addresses in support of all this motion. So, he is not to repeat what he has stated in his written addresses, but to state the relief is seek for, and just use a minute each in respect of each motion for operation.
I am most grateful, my Lord. I am, without flogging a dead horse, I am asking this very honorable court, my Lord, to please kindly grant my prayers as contained in the motion for reference to the appeal court, and may I also identify the affidavit in support. It is only a 6-paragraph affidavit, my Lord. Deposed to by my younger brother, Prince Emmanuel Kanu, also dated the 12th day of November 2025. There is an accompanying affidavit of urgency, which was deposed by my humble self, also filed on the 12th day of November 2025, and also a written address. My Lord, in support of the motion on notice, praying for the orders I had earlier outlined, that too was dated on the 12th day of November, my Lord, may I most graciously ask my Lord to grant these prayers. Thank you very much.
What about the other two motions?
I should move my sometime?
Yes.
Thank you.
I've made an order consolidating the hearing of the three motions.
Okay. The next one, my Lord, is an application, a notice of my commitment to file a final written address, which was dated the 11th day of November and filed on the same 11th day of November. It is accompanied, my Lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my Lord, and I went on to elucidate a body of objection and then the constitutional foundation and jurisdictional limits of this very court.
You all have the grounds stated?
Yes, my Lord, you may. Ground number 1, my Lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the submission of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground 2, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court has jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder.
President Sçärtéred,
which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice, seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my Lord, in its entirety. The third and the very last one is the issue of bail, my Lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025. It is a very simple one. It is a notice, my Lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I enjoin my Lord from ever admitting me on bail, the defendant's applicant to bail on neutral terms, pending the determination of the invalid charge presently before this court, and order my Lord declaring that the continued detention of the defendant's applicant, my humble self, in the absence of a valid subsisting charge under a written law in force is unconstitutional, null and void. My Lord, and
Wow, my dear listeners, this is very simple. This is very, very simple. Nnamdi Kanu is not asking for too much. I believe that it is Nigerian government that is playing the politics here. This guy